Life has a way of changing, doesn't it? What was perfect for your family last year, or even last month, might not be working quite as well today. When your children grow, circumstances shift, or new opportunities arise, you might find yourself wondering if your legal agreements can keep pace. Yes, you absolutely can modify a child custody order. It is a legal process designed to ensure that the arrangements for your children continue to serve their best interests, even as family situations evolve over time. The core reason courts allow modifications is the principle of the child's best interests. A family court judge will always look at what genuinely supports the child's physical safety, emotional well-being, and overall development. This means that to change an existing order, you will generally need to demonstrate a significant or material change in circumstances since the last order was put in place. Without a substantial change, courts typically prefer to maintain stability for the child. So, how do you go about actually making these changes? The process usually begins with identifying the specific, significant changes in your life or your child's life that necessitate an adjustment. Perhaps one parent is relocating for a job, a child's needs have drastically changed, or there is a concern about safety or well-being. Once you have identified this material change, the next step is often to attempt to discuss the proposed modifications with the other parent. If you can reach an agreement, you can submit a stipulated modification order to the court for approval, which is generally the quickest and least stressful path. If an agreement is not possible, you will need to file a formal motion or petition to modify the custody order with the court. This legal document outlines the specific changes you are requesting and the reasons why they are necessary. After filing, you must ensure that the other parent is properly served with these court papers, notifying them of your request. The court will then schedule hearings or possibly direct you to mediation to try and resolve the dispute outside of a formal trial. During any court proceedings, you will need to present evidence to the judge to support your claims about the changed circumstances and how your proposed modifications would better serve your child's best interests. This evidence might include school records, medical reports, witness testimony, or financial documents. The judge will carefully consider all the information presented before making a decision and issuing a new, updated child custody order. This focus on a material change in circumstances and the best interests of the child is not just legal jargon. It is the bedrock of family law, ensuring that every decision prioritizes the unique needs of young people involved. Understanding this core principle helps you frame your requests effectively. A well-crafted modification, even if it requires court involvement, provides clarity and a stable foundation for everyone, helping to prevent future disputes by clearly defining roles and responsibilities. Modifying a child custody order, while a structured legal process, is ultimately about adapting to life's inevitable changes in a way that continues to nurture and protect your children. By understanding the need for a significant change and approaching the process with thoughtful preparation, you empower yourself to ensure your child's arrangements remain as appropriate and supportive as they grow. This proactive approach helps create a more stable and predictable environment for them, which is truly invaluable.